particularly international arbitration, is expensive, and we have discussed this in the earlier session, where comments and discussions were made in respect to this. And in my experience, given the high, quote-unquote, high cost of international arbitration proceedings, which can come up to, I think, standard, even $1 million, parties have given consideration to third-party funding, where, if agreed, funders will finance the arbitration proceedings in exchange for a certain percentage of the awarded sum. Now, having said that, there is an argument on whether third-party funding is legal in certain jurisdictions, particularly those that consider champati as illegal. But the question is whether this would apply to matters that have an international element. The panel that will be taking us through these discussions is already on stage, and I'd like to welcome the moderator who will moderate the session, James Holden. Please let's welcome him with a round of applause. James is a partner in the Dispute Resolution Group in the London office of White & Case, and his practice focuses on international arbitration with an emphasis on East Africa. He has acted as counsel in arbitrations around the world and under the rules of all major arbitral institutions. He also has experience of dispute adjudication both and a broad range of litigation in the English courts, including anti-suit injunctions in support of arbitration and enforcement proceedings. And I think James is the one panelist who has appeared on I think this is the third or fourth event of the Nairobi Arbitration Week. Thank you very much, James, and karibu sana.
Thank you. Thank you so much. And yes, welcome all to this session that we in one case are delighted to be co-hosting with Mohammed Muigai. And thank you to the NCIA, to Lawrence and his whole team for inviting us to present this session and for organising what I think we all agree has been a really interesting and diverse inaugural Nairobi Arbitration Week. Secondly, thank you to my lovely panellists who are already sitting up here, and to you, the audience, for your time, and hopefully we'll have a chance to have some thoughtful discussions this afternoon. So I will get on with introducing the panel. We have Georgiadis Karsegi, who is a partner in Mohammed Muigai. He is a fellow of the Chartered Institute of Arbitrators and has been an advocate at the High Court of Kenya for over 14 years. He practices both commercial litigation and arbitration with a particular focus on infrastructure and energy matters. Next, we have Rob Wheel, who is one of my partners. He's also in the Dispute Resolution Group in London. And his practice also has a particular focus, like mine, on Africa. Robert's handled numerous significant arbitrations, including for sovereigns, primarily in the energy, finance, and infrastructure sectors. Last but by no means least, we have Dr. Mutuma, who is a partner at Kigara and Wine Advocates, and is a certified arbitration mediator. He's been an advocate in the High Court of Kenya for over 22 years, and is also a lecturer at the University of Nairobi. He has studied masters and doctorates in law at both the UK and South Africa, having originally received a bachelor's degree in architecture from the University of Nairobi. Now, without wishing to steal too much thunder from the panel, we're coming to this topic, I think, at a time when third-party funding has been increasingly in the news internationally. Indeed, just last week, Financial Times was reporting on the $16 billion award that was confirmed against Argentina in a case that was funded by one of the major players in this field, Burford Capital. And the FT estimated that Burford could be entitled to $6 billion of that sum under the funding arrangements that it had with the claimants. So it is and can be a very significant issue in arbitration. That said, it's perhaps something that hasn't gained full widespread traction across the world. As was noted, there are certain areas where there's still a debate as to whether third-party funding can indeed be used. So I think it would be helpful to make sure that we're all on the same field when we are discussing this topic. If I'll just ask Robert to give us a very brief introduction to set the scene and explain to us what we mean when we are talking about third-party funding.
Thank you, James. And I'm delighted to be here. Delighted to be speaking slightly less than James, because he seems to be everywhere. But very briefly, I would make a couple of points. First of all, we did do some slide decks, and then when we looked at them, they were excellent slide decks, but we would be here till probably Christmas. So they will be available if anyone wants them from the organisers, but we won't be using the slides today. But just coming to the question that James asked, what is third-party funding? People in the room will have different experiences and knowledge of it. So just to set it out at its most basic, it's when a litigation finance company invests on a non-recourse basis in a case in arbitration in this instance for an agreed investment return. Now, what does that mean? Well, it means if you are funding, if you have a case, and if you let's assume you start at the beginning, you may approach funders, and I'll come on to who those funders may be, and you will show them the case, and you will provide them with information about the prospects. You may need to have opinions from senior lawyers, you may need to have expert opinions, and you invite them to fund it. You'll have to do a budget, and in return for funding that case, or part of the case, they will ask for a return. And traditionally, that has been either a percentage of the proceeds, and broadly speaking, and it is always subject to negotiation, between 30 and 40% of the proceeds, or it's that they always go for the greater, a multiple of the costs, and again that may be 3 or 4 times the costs. If you win the case and you collect, then you pay your 30 or 40% and you will not have paid the legal fees. If you lose the case, the funder takes the hit. So there is an attraction for claimants, particularly claimants who don't necessarily have deep pockets, to get funding. But it would be wrong to say that funding is only used by those who are short of a penny or two. Funding is now being used by people who can afford to bring their claim, but want to spread the risk, and the deal you make is to give up some of the upside. Now, who these funders are is basically many and varied. There are funders who have raised money on the stock exchanges around the world, and they have listed funds. Burford is listed. One of the reasons we know so much about Burford cases is that they have quarterly reporting requirements in the States, and so they have to give details. Also, if you ever go onto the Burford website, it has lots of information, but as soon as you put your email in there, your inbox will just fill, because they will send you an email every day of the week. And some will be wealthy private individuals, some will be hedge funds. It's a mixture of people, because they have seen funding a litigation as quite an exciting investment opportunity. And if they win and win big, they do very well. If they lose, well, they don't do so well. So funders do come and go. And one of the questions you always have to ask the funder is, where's the money? But in terms of the market, and just to give you an idea, it's thought there's about $39 billion of funding in the legal industry worldwide. There is about $2 billion in the UK legal market, and there is probably more funding than suitable cases to fund. So funders will go around the law firms asking about cases quite regularly, and you can have coffee every day of the week again with a funder. The Global Arbitration Review did a survey, and they estimate that there's 249 funded arbitrations in 2021, which is the last year I got data. And that's up from 176 in 2020 and 150 in 2019. And in fact, it's one of those things that you don't have to be a statistician when it comes to funding. because the graph always goes up in a straight line. The amount of money funded, the amount of funded cases is just on the rise at the moment. And I think it's worth also just saying, and then I can pass over the baton, it's worth also saying, well, what do funders look when they invest in cases? And you have to remember, funders are businessmen. Quite a lot of the people in the funding industry are investment bankers, they're not lawyers. They work things out on an investment rate of return that they need to satisfy their investors with. So the first things they look at are the quantum and recoverability. They want to know there's enough money in the case and there's a prospect of getting the money back, because they're not interested in funding somebody who wants to fight something in principle when they're never getting money. They will look at the merits. They want roughly a 60% chance of success, but then that's what almost every client wants, is 60% or better. And then after that, they'll look at who the counsel are, how long the case is, because they need to know how long their money's going to be tied up. But they assess it as a whole full due diligence exercise before they decide to invest in the case. So that's just a very brief overview of funding and how it works.
Thanks, Robin. So, Georgios, I'll come to you next. What have you seen as the benefits of third-party funding in your experience?
Thank you, James, and thank you everyone for the session. When you look at what you can consider to be the most important benefit of third-party funding, it seems to be that ability to give parties access to justice. Parties who would otherwise not be in a position, perhaps, to prosecute some of their claims because of the attendant costs. You realize that in most of these international commercial arbitrations, and especially in investor-state dispute resolutions, you find that the amounts that are involved are quite huge, especially in terms of the damages that are being claimed by the parties. So in most cases, you find that because it would require certain amounts in terms of paying legal counsel, arbitral costs as well, then this provides an avenue for easily accessing such amounts. But I think the point that we need to maybe emphasize, and this was indicated by Robert when he was making his presentation, is that initially it was thought that it is only the impecunious claimants or litigants who would seek third-party funding. However, we are seeing that increasingly, even those parties who are not necessarily impecunious, but because of cash flow constraints, they would seek third-party funding in order to ensure that when they are prosecuting these claims, they are not necessarily constrained by the costs that they incur.
And just picking up on that, Dr. Tuma, what are your views on this of the impecunious, the non-impecunious claimants picking up on these funding things, and obviously funders will often justify what they do on the basis of access to justice. Do you think that's something that is now starting to fall away? Is that still a fair and correct view to be taken, that this is one of the significant benefits?
A fair question. I think anything that has benefits has risks inherent in it. I think that's a starting point. And yes, the argument about access to justice is a fairly heavy one. But there is a range of contracts through which all of this happens. So there's a contract with the financer, the funder. There is the primary duty between counsel and client. And in the world of arbitration, which is generally underpinned by autonomy, tensions will start to arise. Different kinds of tensions. Funders, of course, wanting, because of a sizable investment, to direct how the case will proceed. and that of course falling in conflict with what council and their primary duty to the client may entail, because money now is a factor. Something else that would be quite interesting is in a very small world like ours, where we all know each other, questions of conflict of interest and disclosure jump right to the fore. To what extent would an arbitrator in a very small world like this have commonalities, certain different tribunals or proceedings involving the same funder? I think you quoted one major funder who cascades different areas, and what's the implications that arise from that? I think when you're thinking in a larger scope, and you're looking at some of the ongoing tensions between the private law nature of arbitration, and here I'm thinking the idea of it being contractually based, and the larger scheme in which dispute resolution happens, the public law nature, questions of jurisdiction and questions of various other factors which we've often clubbed down as public policy issues, constitutional issues, where you have now third-party funding. A formidable risk will be the impact of all of that on this private contractual agreement. And I'm saying this cognizant, not just of international commercial arbitration, but the world of investor-state dispute settlement, and some of the bigger issues that are at play there. Rights, environmental rights, communal rights, human rights related to groups of people, and how this conversation then takes on a very different turn, both from the funder's point of view when they're assessing risk, and both, and I think you mentioned that quite well, Robert, that both from an outcome point of view, when they're really looking at what's eventually likely to come out of this proceeding. So it's not as straightforward as just an issue of access to justice, and that's certainly a very big issue. And it's certainly not about spreading commercial risk, but there are other things that are at play that funder would need to be thinking about, and more importantly, any of the parties that are seeking finance and funding should be cognizant of.
Thank you. Robert, you mentioned how there's really probably too much funding available for the number of cases that are out there that are worthy of funding. Have we seen at all that having an impact on the returns that funders are willing to accept, and what has been kind of your experience in terms of the response of claimants when they receive that funding offer, and how they view giving up potentially 30 to 40% of the winnings they might get?
So I think that's a very I think that's a very good question. I think there are claimants for whom there are claimants for whom it's a straight and clear choice that they don't have the funds to bring a claim. And you can take the paradigm case of either someone who's had their investment expropriated and therefore has lost what they invested in, and they're not in a position to bring the claim as an investor-state claim, they want to bring it, and they are destitute because of the actions allegedly of the state. There are other parties who choose not to, there are always pressures on working capital way, and I think the agreement was certainly around about 35–40% again. But they then took an attitude that everything was going to be a funder's cost. And it was a fairly low value claim. It was worth about 10 million, which is about, in the London market, about the lowest you can go. This was was about 7 or 8 years ago as well. So, and so they run up quite a lot of costs. You know, the actual client would expense his trips to London to come into meetings and things like that. And then at one stage, they were looking at the prospects, well, if we got a settlement offer of about 3 or 4 million, the funder would take everything. And there is a real problem, I think, that sometimes claimants forget that there's going to be a day at the end where there's going to be a day of reckoning, there's going to be a decision, either a settlement offer or a hearing, and they may end up with less than they hoped, and that can breed difficulties and conflicts. In my case, they managed to renegotiate the deal, and actually we were more successful at trial and got closer to the 10 million, and so everyone was happy in the day. But it is a problem, and going to the point that was made by my colleague earlier, that it is very much a situation where you have to remember who your client is as a lawyer. And there are 3 in the marriage, is the analogy I've used sometimes. It can get a little bit messy, and you have to make sure that people remember who's who. Going back to your earlier comment, Joe, it is possible to negotiate on the rates. It depends at different times what deals you can get. And you can also try to agree deals where things ratchet up. It doesn't have to be a flat 35% of everything. It could be slightly more of the first tranche, and then as you get more recovery, maybe less, things like that. You can play around with these things. And if you're doing this for the first time, you may want to use a broker or advisor to help you. First of all, with the negotiations, the analysis, but secondly, also with finding the right funders. So in most large law firms will have good links to some funders, but if you are starting for the first time, you're not sure, there are brokers out there who can help you with this, because it's not something for you to sort of dip your toe in without actually having thought it through.
And I think this is now a point that's come up in a couple of comments, but perhaps not directly addressed. But Georgios, what views do you have on the potential impacts that funding can have on attempts to settle a case? And if there are problems, potential problems there, what do you think we can be doing as a legal profession to try and kind of manage those risks?
Thank you. I think because of the interest that the funders gain in the resolution of the matter, we find that in a way they will have an influence on how they will seek to influence how that resolution of that dispute will occur. And in most cases, if there are potential for resolving the same, because of these interests by the third-party funders, it might sometimes even present difficulties, because they are looking ultimately at what they are going to get from the settlement. So in my view, I think it is a good thing, but it has also its challenges, because if the interests of the funders are not taken into consideration when the parties are attempting to resolve the matter, then that can prolong the settlement process. In terms of what we could do, I think it largely depends on the nature of the agreement that is entered into between the funders and the parties that they are funding. And I think if that agreement, the waterfall agreement, is properly structured, then perhaps it could reduce the role that these funders can play, especially when it comes to resolution of the matter. So I think, in my view, that is one way that I can think of playing as a professional.
Dr. Mutuma, turning back to you, you were talking quite eloquently about the problems and some of the risks that can be associated with third-party funding. And I mentioned at the start, obviously, the price interest around the latest Burford Award, and you know how much they might get from Argentina, which is obviously not a state with a significant amount of free capital. Do you think there's a risk with the increase in third-party funding that we see in arbitration that Robert was talking about in his introduction, that we start to see more and more of that kind of story, and it starts to actually impact upon the reputation of arbitration as a kind of neutral forum for settlement of disputes?
So that's it's a question with nuances, I think, that are really worth bringing out. The first is there's a correlation between where third-party funding has peaked and those jurisdictions and how friendly they are to arbitration as a mechanism. So there's a story that's told. I think a lot of the cases have initially have been in the north, a lot from England, Wales, America, and so forth. And then, of course, in the Middle East, specifically Dubai, there was a very concerted effort in terms of reform of arbitral practice and the support, the statutory support that was given to that. And that, of course, then starts, let me put it this way, a stampede of interest amongst which includes third-party funding. And I wanted to use that as a kind of background, because in addition to what Robert has very articulately put, the question of risk also turns on enforcement. And enforcement often is a jurisdiction, how valuable is their work that you have at the end of the day. So the idea has been that many funders will gravitate towards areas where you don't only have a portal that's sufficient, but you're also able to enforce that. So when you're thinking about your classic scenario in Argentina, there is more than just the money and capacity of level to pay, but also the extent to which that work can be honored, and the third party funder gets what they are worth contractually. The other very interesting discussion in this area is you may have, this again riding on what Robert Chichiati said earlier, you may have a contract, but arbitral proceedings don't always follow the estimates that the council practitioners will put out there. You might be on a spar with a very vexatious opponent who throws all kinds of applications to you, and the costs spiral. Arbitration is not so precedent-based, and their work can be sometimes quite a disappointment. So that then throws the entire arrangement into very unstable terrain. And there are indemnities when you look at a lot of LFAs, because a lot of this has been in the world of litigation. There are indemnities that are put there. But your worst nightmare is your partner feeling exasperated, and somewhere along a long journey, they start to get cold feet, and there are dismounting costs that have sort of crept in. So that's a very interesting scenario. I did want to say, when Julius was speaking earlier, that the idea of capital and being able to prosecute or defend a matter is almost a double-edged sword. Because on one hand, you realize, I mentioned earlier, you lose the kind of autonomy that a party has. You run into problems of where the third party funder wants to settle and could possibly the other, the primary litigant, the claimant, for many reasons, may not want to do that. But the positive side, the upside to all of this is that just the existence of a third-party funder is a very powerful message when it comes to a sector. For one, it means that you have a flow of support, financial support, which in many of the cases that you see in class actions would be a considerable determinant. The other, of course, is this would go through an investment committee of some kind. They would do their due diligence and things like that. And your opponent will be well aware, if you're in the context of disclosure, that the very existence of a third party financer means that you may very well have a very strong case. And that has a way of bringing them to the table, or at least taking you seriously when you're talking about a settlement. Yeah, just some of the issues that
Yeah, I wanted to add something, and because it has been raised by Dr. Mtuma, that aspect of perception, because it is not only to the opponent, but sometimes even to the tribunal itself. And if that disclosure is made, and looking at the amount perhaps, because we have different requirements for disclosure, if perhaps the tribunal were to be aware of the extent to which the party has been financed, then it can create certain perception to the tribunal insofar as the weight that is attached to that particular.
to be honest, James, we almost feel like dragging you into this conversation. Someone said something quite interesting, and you get a thought as you hear that. I mean, of course, the whole issue is disclosure, the question of disclosure, and what different jurisdictions have to say about that. I know the ICC has done some work in this, but it's a very interesting one. Thank you.
Sorry, just jumping in on that, exactly right. So the ICC, in its rules, I think it's Rule 11 or something like that, if you have a funder or you are funded, you have to declare it, because it's seen as the funder has an economic interest in the case, and for the reasons Dr. Mtuma and others have mentioned, there may be links between that funder and members of the tribunal. Now, those links may be links you need to ask questions about, or they may be entirely natural. You know, if a white case partner is your arbitrator, it may be that another white case partner has some funding with Burford. Through the ICC process, it's also on the arbitrator form, you will get disclosure of that. So I have cases where I'm against a funded party, and we've had disclosure that there is a funder in, and then one of the tribunals said, well, we've had some cases with that. And then you write a very polite letter saying, are you actively involved with that? You have a correspondence, and then you form a view on the risk, because you have to work out whether this is something that is just natural, the same way as tribunal members may sit on committees together, or maybe sitting on other arbitrations together, and you form a view, or whether this is something more sinister and someone has, their firm is basically in hock to a particular funder and only does their, done 20 or 30 live cases for that, and now they're funding someone who's in front of them. That looks a little bit more suspicious. ICSID has a similar rule about disclosure, and if there isn't a rule, you can invoke the IBA rules on the conflict of interest, because they get the same thing having disclosing people with an economic interest. So there is soft law even if you don't have actual rules on it. So I think the disclosure point is the important one, and you can try and make a strength of it, as was being said, is that third-party validation that someone else has backed it. You have to remember, if you're on the other side, that funders do lose cases. Just because someone's put their money in, it doesn't mean that it's a winner. But the disclosure issue is really very important to this.
Well, I think that then gives us a nice segue into looking a bit more at the regulation of third-party funding on kind of a global scale. And Robert, I was wondering if you could just give us a kind of brief overview of the kind of different regimes that there are in the world and different views taken on third-party funding.
So I've been following funding for about a decade, and it's very interesting to see how what started as a ripple has become something much bigger. And so there are two approaches to this. Well, sorry, there are three approaches to it. The English law position has been alluded to with maintenance and champity being criminal offences and torts. And one of the gifts of the English common law is that means there are a number of countries who have a common law heritage. You also have the concept of maintenance and champity. So my understanding, if I stand to be corrected, is that Zimbabwe, Uganda, Ghana, Rwanda and Tanzania are all countries where there is currently an issue with maintenance and champity, so it would make it difficult to have an agreement governed under those laws. Other countries who have been afflicted by that English gift have actually legislated. So Hong Kong, Singapore and Nigeria have all taken steps, and in their legislation they expressly say for arbitration, not for their own domestic litigation, but for arbitration, that maintenance and champity don't apply. They say it's like forms. And then there are other jurisdictions who have basically, which is actually the route England has broadly taken, have evolved the position through common law. So in South Africa, my understanding is that funding is allowed because access to justice is perceived to be a good thing. And there's case law on that. But there is also then an examination about the proportionality of the rewards. So if it's felt that the fund is somehow disproportionate, that may be an issue that the court will step in and look at. But there is funding in India, again it's been seems to be done through case law. There is funding in China. We reported on 2 cases in China where the Chinese courts were ruling on funding agreements. So it is something that is everywhere. And for venues that want to be arbitration hubs, there is a perception, rightly or wrongly, that you need to allow third-party funding in arbitration. And I'm sure Hong Kong and Singapore did it expressly for that reason, and in a great race to see who can be there first. Nigeria has done it as part of its acts, and that may help Lagos to attract more arbitrations. And then you get other jurisdictions like Ireland, which are not particularly known for their dispute resolution and passed laws to do this. So that's the sort of the legal framework, different ways of approaching it. But there is very little more generally by way of regulation. And actually, considering the amounts of money that are flowing around in funding, there is very little regulation of funders. In England, the Ministry of Justice decided it was too complicated, so they didn't oversee it. And I think there is probably going to be some problems down the line, because every now and then a funder will hit financial problems, or they'll withdraw from the market, or they'll do these things. So there is space definitely for funding. In Europe, the MEPs in Parliament have a report which is to try and regulate funding. It may never get anywhere, but there's a perception in some markets that we need to regulate this space because it's if not the Wild West, it's certainly not got a lot of controls over it.
And George, a lot of the discussions over the past 2 days have looked at ways of trying to make Kenya more into one of those arbitration hubs, and the role of the NCIA, the judiciary can play in all of that. What is then, given what Robert was saying, the position in Kenya on third-party funding, and do you think that there's more that needs to be done to encourage potentially third-party funding in Kenya as a way of developing Kenya as an arbitration hub?
Thank you, James. I think just taking on from where Robert indicated, Kenya being a common law jurisdiction, of course the issue of third party is outlawed. However, I think in the context of arbitration, and also by the fact that we apply the common law, I would argue that when it comes to arbitration, I wouldn't have a problem. I don't think there's any problem when it comes to third-party funding. There is a very interesting case in the United Kingdom which involved third-party funding, where the arbitrator had awarded the costs that were incurred by a party in securing third-party funding. And the respondent who lost in that particular case went to the commercial court seeking to set aside that award. And in so doing, they were saying that the arbitrator went out of his jurisdiction or outside his jurisdiction in awarding those costs. And what I find interesting, and that is how I want to juxtapose it in the Kenyan context, is that the court in that particular case, the case of ESA versus Noscot, I think some of you might be familiar with that particular case. The court declined to set aside that particular award, and the argument by the judge was that if you look at the UK Arbitration Act of 1996, there is that provision that allows for award of legal costs and other costs. And he said that third-party funding costs actually can be encompassed in that aspect of other costs. So when you look at the provision under which those costs were being awarded, Section 59 of the UK Arbitration Act, and you suppose that with our very own Section 32B, which allows the arbitral tribunal to award costs, you will find that there is almost similarity in language. Although the Kenyan Arbitration Act does not talk about costs, but it talks about legal costs and other expenses of arbitration. So my argument would be that when it comes to arbitration, looking at this decision, I would argue that in the context of arbitration, third-party costs would not be outlawed necessarily.
Thank you. Dr. Mutema, I wanted to now kind of take us back up to a bit more of a global view, and I wondered what your views were on what more needs to be done on the regulation of third-party funding, and whether you think we could get to a position where there's a kind of global standard on this thing, rather than having, you know, the slightly disparate different rules out there that Robert was talking about, and maybe the need to kind of eventually look up to some IBX off floor as further support if you need it. Can we do more than that?
So every time you have a new phenomenon creep up, the next question is, because it builds momentum, is how to regulate it. And how do you make sure all other, including ethical, professional issues, are actually addressed. So globally, what we have seen is a bit of what my two colleagues mentioned earlier. Robert talked about their position in different statutes and courts, which in many cases is very express that there is nothing that prohibits third-party funding. In other cases, just blanket prohibitions like Rwanda, as some of the cases that were mentioned earlier. So statute is certainly one way that this sort of creeps into the discussion. You know, do you take an approach which is domestic around what we've seen in many other areas of arbitration, built on the model laws coming from reputable institutions and so forth. Then, of course, that is not just the only approach. I think this is also one of those areas where self-regulation is big. And I'm thinking here about the LFA and the code that they've put together that regulates the conduct and the behavior of third-party funders, sort of brings them the association, the American body that's brought third-party funders in under one umbrella, and with very clear express references on how they should conduct themselves. Self-regulation is a hit and miss because it relies quite a lot on numbers, and the number of people that subscribe to that court, and we're in the space of international commercial law, transnational agreements. So how do you build that critical mass? The other approach is what Robert had mentioned earlier, moving and addressing the issue through arbitral institutions, whether that is the ICC and the rules, the NCIA and different centers that have administered arbitrations, the Chartered Institute of Arbitrators and so forth, and then seeking to, in a way, bring in all the issues of disclosure and how disclosure should take place, questions of conflict of interest, and so forth. But I find the relationship between regulation and specifically let me talk about statute and activity quite fascinating, because in many ways law often acts as an enabler, and I use the example of Dubai, when Dubai expressly recognized third party, provided a setup where third party funding was an accepted norm, then you saw an activity moving. So that is quite interesting. But to dovetail back on what Georgiadis was saying on the question of cost, I thought the spirit of our act is quite clear when it comes to how the court would actually address that. I think the idea of reasonable costs, reasonably incurred, is, though we haven't had too much litigation around that, it's something that would certainly come in the mind of a question where an award is challenged and ruling goes before law courts and so forth.
Yeah, yes, just to add on what Dr. Tuma has indicated, and my colleague Robert, I think when we are talking about regulation, it would appear that in modern times, the issue really is not to look at third-party funding in the previous context. I think there is a more, you can say that the current move is towards accepting third-party funding, especially in arbitration. The question that perhaps we are more concerned about is to what extent should these regulations go. And you find that some jurisdictions have basically provided for disclosure of these agreements between parties and the funders. And more recent ones, if you look at the exit arbitration rules, especially Rule 14, which provides for third-party funding, it is perhaps the more detailed one, and which requires not only disclosure of that third-party funding agreement, but even the details of the identity and the people behind it, if it is a corporate entity, behind the entity that is providing the funding. So you'll see that the move really in international arbitration is to encourage it and bait to different or to varying degree when it comes to disclosure of the funding agreements.
So the other kind of, as well as disclosure and all of that, the other big thing that often gets mentioned in relation to third-party funding is security of costs. So the respondent party saying, well, if you need funding for your costs, what's going to happen if you lose, and I want you to pay my costs? So I'd be interested in getting the views of each of you on really whether we need to have a more systemized process for awarding security of costs in arbitrations, and what you think the key considerations for a tribunal should be when considering that issue. So if we start with you, Georgiadis, we can then go down the line.
Thank you. I think the considerations that should be taken into account should not necessarily be about the status or the ability of the party to meet this cost. I think the tribunal can take into consideration various factors, including perhaps the conduct of the parties during these arbitration proceedings. I would be more inclined towards that particular approach, because sometimes, unless a party completely brought a vexatious claim before the arbitral tribunal, I think other consideration other than the monetary standing of the party should inform the tribunal when looking at that.
Thank you. I think it's a very interesting question. There was a lot of excitement when some security for cost decisions were made. I think it was the St. Lucia case and others. And for a while, people were trying to argue that the fact you had funding means you lacked money. And I think that has been debunked. I think there's an ICA task force and things like that have looked at this. Having made and successfully got security for costs against the funded party, it was very clear, both from us, we were acting for a state, and from the other side, that the fact that it was funding was the start of an investigation, the start of the application. It wasn't, you've got funding, you're bust, I've got funding, I'm flush with money, what are you talking about? What you have to do, and what we did in that case, was we made a security cost application in a way that most of you will have made in your practices. So we pointed out, we're being sued by an SPV that had negligible money, that its account showed very little activity, was arguably dormant. And then the funding bit came in by saying, well, if the funder wants to put up a bond or something as a security for costs, of course we're happy to consider it. But absent that, the tribunal should make order security. And there were about 3 or 4 rounds of briefs, that they always are, about it. But it was very clear always that the funder would not put it up. And so we just kept jabbering away. And there is an actually interesting, there's a Burford, the person who runs Burford, Christopher Beaumont, had written something about smash and run arbitrations, where the funder goes in, because the funder is the party to the arbitration agreement, they're outside of that, so that they can't make an order against the funder directly to the tribunal. So our argument was, well, if you're not giving that assurance, this is smash and run, because you're going to run the case. If you win, you take your money. If you lose, you're going to disappear over the horizon, we'll never see you again. And we were successful, and I think the tribunal got very frustrated with the other side trying to hide behind funding, but not being able to show that there was any commitment from the funder. And ironically, we were then given an award, so they had to pay several billion in security costs. The arrangements for doing that were very protracted, and it was done through the escrow arrangements with the ICC, at which point the ICC, as we knew we were deliberately provoking them, has to know where the money comes from, because he can't just hold money, he doesn't know where it comes from and why that money. And it then became clear that the funder had put up some money for the escrow. So they'd gone through all this pay without putting up the assurances that we'd been looking for. And then obviously faced by no other way of raising the money, they had come good in that. So as I say, it's not the answer to the should we have a wider global system, but I think in terms of security for cost, you have to focus on would I get security, how does the funding situation play in this, rather than just go, well, they're funding, so I'm entitled to it.
And all of that must be in the backdrop of the question that you started us off with earlier, this idea of access to justice. I mean, that's the general discussion is framed within those parameters. And I've always found it very interesting sitting in a tribunal and faced with an application for security of cost to weigh what is quite common in our different statutes, which is balancing this balancing effect of making sure the process moves forward expeditiously, but that you're not denying any party the right to make very reasonable representations on their claim. And that, I think, is, just building up on what Robert said, the idea of debunking, that the only reason why a claimant would bring a matter and the only consideration in an application of this nature is how much they're liquid. So that's the only reason that they resorted to a third-party funder. There are so many other reasons that could actually be driving that aim. And when you look at jurisprudence, you will see class actions, you will see so many other considerations that a tribunal should, quite correctly, be cognizant of. Boardroom rapture, I think, is the other very common context in which third-party funding comes to. So yes, I completely concur with my colleagues that just because you sought finance or funding in this area does not mean that you're broke. There are several reasons why you will do that. And Robert, to throw back your very earlier input, this idea of spreading commercial risk, making sure that your books are attractive, is a very, very powerful motivation for claimants that will seek financing. So it's not that they don't have the money, but they would rather the money is used for other more, in their perspective, more valuable endeavors.
Just to add one point, because I think you'll touch on a very important issue. What you have to remember with litigation funding is a contract. And depending on the case, if you have a case where there are fraud allegations, or you have cases like that, you may find that either the funder backs out because they have terms in their agreement that say if material facts change or if they've been lied to or this sort of thing, they may back out. Likewise, the case may develop and there's a final award and the fund pulls out. So you really want to, if you're going for security for costs, you really do need to get certainty that if they're going to put up some assurance, it's going to withstand what's going to come out of your case. If it's a plain vanilla commercial case, it may be fine. But if it's something where there is fraud and allegations of dishonesty or something like that, or other things, the funder may be off. So you need to make sure if you're asking for security costs and the funder's going to give some assurance that it's sort of come what may. They can't withdraw that. And that's one of the reasons why we took the escrow agreement, because it was then in the tribunal's hands and they could make the order and they were the only people who could take it out of the ICU payers. But it is an important thing to remember, the funding agreements, they often have exit clauses that allow the funder to go. And you don't want to find that you've been relying in some way on that. So I think that's important. The other thing I would say, going back to the discussions earlier about disclosure and things, although I'm in favour sometimes of criticising funders, you have to remember that the funder, they want the award to be upheld. Assuming they win and they get an award, they want that award to be upheld. So they are generally pro-disclosure. They are generally, because they don't have a challenge. I mean, I'm not saying they are perfect or angels, but on the whole, with a lot of these things, they would rather there was disclosure. They don't want a challenge being made after an award that there was some serious irregularity they've only just learned about. So, as I say, it's not a perfect answer, but the funders, they're not always cloak and dagger. Sometimes they want these things to be out there because they want their award to stand up and they say collectively.
I wanted to just kind of switch up slightly now and move on to what we see as kind of the future of third-party funding. Now, there's been quite a lot of press.
At least in a global commercial context where an activity is unregulated, there is a clamour that regulation might, with it, bring some kind of legitimacy in that activity and reputation. And contrary to what I think one would anticipate, it may not lead to a recession of activity, but a promotion of good and upstanding entities in that space.
Georgios, what do you think really the future of third-party funding is going to be, particularly in an African context? Are we going to see more development in this area, do you think?
Yes, because I think it is gaining currency, and if recent happenings are anything to go by in terms of legislative reform, I think earlier on when Robert was giving us an overview, and also when he was touching on the issue issue of regulation. You just mentioned about Nigeria, the recent Arbitration and Mediation Act, where I think perhaps it is one of the most pronounced legislation when it comes to third-party funding. I'm seeing a trend perhaps by other jurisdictions, other countries in Africa, perhaps following the same route to try and be attractive as seats of arbitration. And also, I think increasingly as more countries ratify the New York Convention and therefore are seeking to have international arbitral awards enforced within the jurisdictions, then we'll see that perhaps this will also expand. So I'm seeing a situation where in future, with modification of more arbitration legislation, then with the fact that this issue is gaining currency and that it is gaining acceptance as opposed to how it used to be initially, the challenges that were thought to come with a third party being involved in a matter where they are not parties, and the ethical issues that pertains to the arbitral tribunal. I think the future for me in Africa is more acceptance and adoption of third party funding. Perhaps the only issue would be to what extent would this legislation define the disclosure requirements, and to what extent perhaps it will be important when it comes to issues that we have discussed, like dealing with security for costs and so on. So it will play, I think, more of a facilitating role in the future.
Yeah, and I think I was just listening to you, Georgiadis, and I was wondering where in this new areas, and I'm speaking now from an African context, what is the fastest way to play catch up? For various reasons, third-party funding may not have sunk its teeth properly here. A lot of funders would be interested in arbitration who are considerably worth. So you have a catch-22. How to get your arbitrations into that scale, those kind of figures that buttress the activity where funders will move into. I think both the jurisprudence in this area and statute would be a bad place to look. We are very monolithic and slow, but the institutions might provide a catalyst to how we would support the trends that we're seeing in different countries. So the ICC, of course, has taken a lead in this, almost drawing what we see in a few civil law jurisdictions into its rules. I would imagine other entities like the Chartered Institute of Arbitrators should be thinking way ahead and redefining their rules. So what we saw with the virtual platforms and everyone scrambling after the fact is something that I wish would not change that. Sort of technologically go ahead and use the perfect environment to attract investment in business. So that's my look. Operating as a seer, I see quite a few organizations, and SBI is here, beginning to do some serious work when they look at their rules and think around how those rules would be supporting third-party funding. Thank you.
If you permit, just wanted to add that I think in terms of the equilibrium, giving that overview and maybe in support of this view that we are likely to have interest around that funding and perhaps regulation around the same. If you look at investor-state disputes, you realize that increasingly they have been on an upward trend. At one point, like if you look at Kenya, we had very few. I think the World Duty-Free case was the more famous, but we have had almost 10 investor-state disputes. that regard. And we have had experiences with third-party funding when it comes to some of these issues. When you look at the Kotek mining case, it was third-party funding. So, of course, as we go forward, we find that there will be increased interest around the issue of third-party funding because of the experiences that these countries have in those issues.
Yeah. On that, I think leads on nicely to my final question, because I'm sure there'll be a few questions on the floor which I want to leave a bit of time to, but ask each of you briefly to just give a couple of thoughts on whether you see there being scope for third-party funding options developing for respondents, especially states, and what form those might take.
So classically, claimants are the people who are funded, because it's much easier because they have a claim and therefore there's going to be money coming in if they win, and that's how you fund it. Defendants, or respondents rather, unless there's a counterclaim, don't tend to have that. So it is possible to fund, and there are ways and means by which to do it, and funders will provide support, reduce legal fees for the conduct of the defendant state. But the difficulty comes is, first of all, you have to define success. So success may be, we're being sued for 100 million, if we bring it down to 50 million, we get this or this. But the second thing that has to be thought about is, well, where does the money come to pay that reward? Because you and let's assume it's the state, you have successfully knocked out half this counterclaim. That's great. But actually you haven't got any money in, so there has to be some money allocated in a budget somewhere to pay for the funder, because the funder goes, okay, I funded your defence, I paid my 5 million to fund your defence, I got the counterclaim down by 50%, I now want my bonus. And that's when the state, respondent, whoever it is, has to come up with some money. So that tends to be the stumbling block. You can see why there are attractions for that, because you talk to some states who had very bad decisions, not Kenya, but very bad decisions. And part of that is because they haven't paid for quantum experts, or they haven't paid for this, or they haven't paid for that. And so a funder coming in, helping and paying for some of that, might have immensely reduced the claims. But there has to be a pot at the end to reward the funder. So I think that is the problem.
I'll sort of pick up from where Gigiadis left investor-state disputes. And there is a flurry of discussions when it comes to the contractual sense of those disputes and the public duty of states to different social actors. A lot of them are shrouded in issues sometimes that border the environment and so forth, like I said earlier. So states are exposed for various reasons in the entire lifeline of that transaction, the contract. And that sometimes that exposure will inevitably lead to a dispute where the state doesn't have, is not as well resourced to address or to defend itself. I'm glad, Robert, you cited Kenya as a good example. I'm doing that by, if we are not a bad example, we must be a good example. So by default. But the other area, which is we've seen from jurisprudence in the north, is the cases related to activism that often get companies. There is a case with the Royal Bank of Scotland. Your customers, your stakeholders, consumers are highly cautious, and many times an entity, a respondent, could find themselves overwhelmed with a surge of litigation that they need funding. So the power dynamic that we're used to between a claimant and a respondent is shifted because you're looking at multiple actions taken from across a wide range of interested parties, and you are one respondent. And that would lend itself very well to a feature for third-party funding when we're looking at respondents.
I can also add my voice. I think I agree with my colleagues. If you look at the statistics and most cases, it's actually these third-party funders go after mostly the claimants. And of course, it is for good reason, because they are looking at the amount of damages that is at stake. That is how they will structure their agreements and what they will be able to do. There is really no clear agreement as it were. So it is either as a percentage of what will be awarded, or as to be multiple of the amount that has been awarded. But we are also seeing that sometimes, and I think that is to go back to the question of if at all respondents can also be funded. We have seen that when we come to the realm of ICPS, we have had states also being funded. I think come across the case of another, which was funded, but we see that the third-party funder in this particular case seems to have an interest in the eventual outcome of the matter, not necessarily in terms of the damages, but perhaps you find a matter where maybe a regulatory issue is being challenged in such a forum, such that if the claimant were to be successful, then that third party would also suffer. So they are funding the respondent in order to ensure that they can successfully ward off the claim, so that their interest is then preserved. So we have had those instances. I could also think of situations perhaps which it didn't occur that way, but when you look at the case that India was going to fight off with Vodafone on the issue of payment of taxes, such that if India succeeded, then it means that Vodafone would have to pay those taxes. So in that particular case, you find that a third-party funder can come there, because he's saying, if we are able to assist you to ward off this challenge, then this is the amount that you are going to get from this taxpayer. So maybe they can structure their agreement, their funding agreement around such a thing.
Thank you all. I hope those in the audience found that helpful. Let's open it up to some questions from the floor. Come over here first, and then once we've had that question, we'll get answering it, and then we can swap over.
Good afternoon, everybody. My name is Amelia. I think for me, thinking about third-party funding and the question you asked around Africa and whether there would be an uptick. Thinking about it, yes, in arbitration, because arbitration is expensive for parties on the continent. So there is a case to be made for third-party funding as it relates to arbitration, but not for litigation. Litigation is very cheap on the continent, very, very cheap, and that's part of the problem, that it is cheap, but you spend a lifetime before the courts, so that we say you at least you buy out some part of your life by going to arbitration. So I think that there is a market, but it's how do we promote that market for third-party funding. And just to say that I'm Nigerian. Nigeria was effectively funded for Transocean, that they ended up winning. So states are transparent, me coming from one, so that we don't understand. Me personally, I think that the new exit rules is the way to go.
Good afternoon. My name is Mary Angawa from Nairobi, Kenya. Can you tell us where there are countries where they banned third-party funding and the reasons why? they've rejected third-party fundings, and the reasons why. Thank you.
I'm not aware of anywhere that has expressly banned it. Obviously, there are countries where there are prohibitions in place. So taking Nigeria as an example, it would have been illegal until the latest Nigerian Arbitration Act. So they have taken away the impediment. But I'm not aware of a country that has said, we're not allowed this. It will be open, possibly. Maybe there are case law decisions in other countries which we haven't read that have said we don't buy access to justice here, or we don't, this offends it. But I'm not aware of anyone who's gone the other way and said expressly this can't be done.
Okay, I think I agree with him on the. Initially, when we were talking about it, we were looking at it in the context of litigation, perhaps under the chapter and the doctrine of maintenance. But I would agree with them that expressly happens in, and I think that is the point I was even initially making, that it is arguable that if you look at some decisions, including Kenya, that we could actually, the community tribunals could actually award or allow some of these costs that are associated with third-party funding, if we want to look at the way the statute is couched.
Yeah. Then, Amelia, it's the age-old question of what is cheap and what is expensive. And I hope my good professor Izobuge would weigh in on that, whether arbitration is expensive or whether it is what is cheaper. I mean, these are all relative terms. And you led us on because what is the cost of half your life? I mean, we've had litigation matters that on for 20 years. I came from aviation not too long ago, and I think the carrot I was hanging out in the Caucasus was you've got a valuable property and the bank has its hands on it. What will it cost if you're looking for this? If you stay for another 10, 20 years, what have you really lost? And that relationship may explain why in this particular jurisdiction big actors transcend now to arbitration. The contracts are so clear, no one wants to go to court. I don't know whether the Prof will say something, whether we are now back on reverse trajectory and people are saying arbitration has become equally as lengthy and thickening. But I do agree with what you have very well put, that there is a huge market, and I think I am of the opinion that if you throw out some fillers from a regulatory point of view, you will have what we've seen in many other areas, a movement towards the south, and that movement then will lift the water when it comes to how justifiable it is for a third-party funder to invest in a case. Prof, sorry, I put you on the hot spot, but I do enjoy your remarks when you talk about what's expensive and what's cheap.
Thank you. I personally think that arbitration in Kenya can be made more fun. I think that we, the arbitrators, I've said this in other forums, and I don't think I've made friends. I think we cost more than we should across the board. Because like I used to tell my students when I used to teach professional ethics, you can have a client who pays you 10,000 shillings every month for the next 20 years. Or you can have one client who pays you 1 million and never comes back to you. I think that at this phase where we are taking off, we should not be costing so much as to deter people from coming to us. And once we've taken off, we can be competitive. That's what I think. As regards support for arbitration from third parties. We will be talking about this shortly. I think that there are several ethical challenges around it, and I personally feel that sometimes one doesn't see sufficient disclosures that probably would change the character of the process if this was known to everybody. Currently, I am engaged in a matter in the London court supporting a state party. And during disclosures, we threw out the question, are you third party funded? And the question the answer that came back was no, and nothing more. So we are not the wiser. We are not the wiser. Supposing they became third-party funded the day after they told us no, are they under an obligation to? So those are my thoughts about that.
Sorry.
Yeah, I think just on that issue of Prof, I think that is why I agree with the Prof you are saying. When it comes to like the incident, the model, which goes that extra mile of saying that as soon as that happens, then you still are under obligation to make those disclosures.
Okay. I think this might have to be the last question.
Namachanja from Kenya. Just I think, of course I can't ask in James' question because you're moderator, but you said your focus is this side of the continent. What is the level of third-party fronting in Africa or East Africa? I think Robert could pick up that. And then, third-party funding and chamber maintenance. If we were to remove the aspect of access to justice as the limb that is weighed out by third-party funders to do their business, how would we actually describe them? And can it then be established, or to what extent can we say that they are actually corporate entities out in business, and the particular focus is this area? So that if it's well understood, then probably regulatory frameworks can be put in place and they are allowed to do their business. In other words, why use the carrot access to justice to beat the age-old argument of champion maintenance within the UK context and Commonwealth or common law countries? I say that because the third-party funders have now extended into corporate financing, so it's just not a question of that the claimant is impecunious. It is now a corporate finance tool that is being employed. So if we were to remove access to justice facet, can they find another way of doing business within the international arbitration circles? And especially the hesitancy in defending the respondents. Don't the respondents also have a right to justice by defending themselves effectively? If access to justice is the issue. Then in the context of active roles of lawyers with third-party funders, of course it boils into the ethical considerations that will come after this. But to what extent should lawyers look for third-party funders, and then to what extent should the tribunals be involved in this process? Which then brings in the aspect of a common term in insurance matters, ambulance chasing. If I, as a lawyer, am going to look for this third-party funders to aid my client, and I think, Robert, you mentioned earlier on that they regularly knock on your doors. Do you have a claim? Do you have a claim? That's a typical concept of ambulance chasing, but at a different level. So if we put all this boiling down to the issue of regulation and their argument for self-regulation, just your views on that. Probably no hard and fast answers,
quite a lot wrapped up in that. Funders are very good at coming round to chat about the markets. They don't come around and say, have you seen any ambulances recently? They come and chat about the market. Actually, in the English regulatory space for lawyers, for the Solicitors Regulation Authority, we have to discuss alternative means of funding with our clients. So it's something we have to discuss. Doesn't mean we have to push it, doesn't mean we have to promote it, but we have to be willing to discuss it. And with some clients, it's, well, I've got the money, I don't want it. With other clients, yes, I'm interested. But if we didn't, we would be in breach of our duties and arguably negligent. So there is an angle there we have to. There is another regulatory piece that, again, typically lawyers will introduce to funders. They may also introduce to brokers if they want to do it. There is a piece about regulatory licensing for whether you advise on the actual products and the financing, which is quite complicated. You find a lot of sophisticated clients who do international arbitration are more than capable of understanding this form of financing. You are absolutely right that third-party funding is corporate finance now. I mean, if you go on the Burford website, or you go on any of them, they will do corporate financing, they will do all sorts of things. And they would like to do portfolios, so if you have a whole series of cases for one client, they'll fund a portfolio, give you cheaper pricing, they will buy and sell awards, they will lend you money against enforcement proceedings, they will do all these sorts of things, they will give cash flows to law firms if they want. There are some claimant firms who have paid for offices with tie-ups with funding. So this is a big market, and I think you have to go into it with your eyes open. I've forgotten some of the other questions. I mean, there are people who specialise in Africa and funding. People like Bobby Bridgeway, for example, are very active in this market. Burford has funded a lot of claims in this area as well. Tanzania, when it had its issues with the mining licenses, suddenly got 12 claims against it, and most of them were Burford or Bobby Bridgeway from what I've seen in the press. So I think I probably ducked part of the question, but I've tackled a fair bit of it.
I think it's well, that is a philosophical debate to some extent. I'm not beginning on whether this idea of corporatizing activity clearly cleanses it from its root and that exposed sense of surety and maintenance. And we all, in our careers, one time or the other, when he mentioned accident cases, I think the common phrase we've used here is running down matters. And that was quite common. I'm sure you have the same thing, Robert, where people chase ambulances and with the expectation that they would have a vested interest in the spoils. I think there is a difference, Bollywood slightly. There's a difference because the thinking behind that, if you think about the fiduciary duty of an advocate and the fact that he is right in the trenches when it comes to prosecuting or defending a matter, and the fact that that individual has a vested interest, and then you contrast it with the series of contractual relationships that exist, one between the third-party funder and the claimant, respondent, and the lawyer and his client or her client. I think a lot of the fidelity issues still remain intact. And indeed they remain intact because accountability works still in the primary mode that we're used to, where you are accountable to your client, even though you may have a reporting system of updating a third-party funder that is outside that primary relationship. So I was thinking, I was also wrestling with what you were saying how is this very different from the crude and crass interests that we all know that advocates have when they're taking up on a running down matter? So that is my honest opinion. I think the tripartite contractual relationship still maintains some kind of philosophy, some kind of integrity in relationships. But I do recognize that there is a strong debate on this subject where it's often said that corporatizing activity has a way of creating some sanctity in that activity, while it's still the age-old crass activity that existed before. Julius, yeah.
Yeah, thank you. I want to respond to three issues or three comments that you made. One was on the issue of access to justice, and in the African context, where we see these activities around third-party funding more pronounced, and I think is the nature of these third-party funding arrangements. Now, on the first issue of access to justice, I think the point that you make is quite interesting and valid, because if we are making the argument that it accords access to justice in the sense that the claimant is able to prosecute, then it leaves the question, what about the respondent? And as we have indicated here, it would appear that most of these third-party funders actually go for in most cases, for the claimants. So in a way, it creates that imbalance, and I would agree with the argument that you make. Is it just access to justice if we are funding the claimant and not the respondent? So I think that argument that you make is quite valid. Perhaps it needs to be looked at from both angles. But again, it boils down to the reality of the way these agreements operate. Third-party funders are going for situations or parties who they are likely to make the most profit. If it is a respondent without a counterclaim, the most that they can do is to ward off the claim and get some costs. And if it was the claimant, of course, other than cost, there is the element of damages, and that is how they structure their waterfall agreement. So at the end of the day, it is, I think, the reality on the ground. In terms of the experience, I think South Africa is in the continent has attracted a lot of third-party funding, and there's a nexus, and the reason why perhaps we can explain that is the case, of course, knowing that it is the biggest economy. So you find that the quantum of damages or claims that are involved, perhaps from those jurisdictions, would attract funders to fund disputes in that particular jurisdiction. And locally, of course, when you look at domestic arbitrations, in most cases, maybe the argument can be made that they might not be attractive, because at the end of the day, the claims that are involved might not be such that can involve big corporate third-party funders. As to the last issue, the role of advocate, I think what you reminded me, we are, especially because the membership of the arbitrators here, most of us are also advocates. I think advocates at one point or the other have been third-party funders. Maybe we just don't know. In most cases, these contingency fee agreements, sometimes you do matters, you take up matters for clients on the basis that ultimately when they win, you can take something from that. That happens. I know maybe there are issues around that. But we are seeing in other jurisdictions that in terms of the nature, even insurance companies are taking up that role. And as Robert indicated, we have had even funders, corporate funders also doing or taking that. Perhaps the only issue in our local context would be the enforceability of those agreements if they were to come to court. If there is a disagreement around the implementation of the same, in view of the fact that we said initially we have issues around jump party and the litigation Commission context.
Well, thank you all. It leaves me just to say thank you to everyone, in particular the panel, for a lively discussion. We will briefly switch panels over and then continue on with the next part of the debate. But please, a round of applause for this panel.
Another round of applause for the panel. We have agreed with the panelists that we will move on to the next panel, and the photo and the gifting will be done at the end of the session. So moving ahead to the second panel of the afternoon, we have a panel that will be discussing the ethical considerations in commercial arbitration. And I think this topic has been alluded to in the morning, the judiciary event, where there were discussions around impartiality of arbitration, again guidelines on conflicts of interest, and perhaps the need to have a code of conduct to govern arbitrators. The moderator who will moderate this session is Mr. Geoffrey Imende, who I will request to join us on stage. Give him a round of applause. Mr. Imende is a fellow of the Chartered Institute of Arbitrators, Kenya branch, and an advocate of the High Court of Kenya. He is the managing partner of Mohammed Muigai LLP and has over 18 years of post-qualification experience. He is involved in arbitration disputes both as an arbitrator and party representative. He is a dispute resolution practitioner specializing in constitutional and administrative law, employment and labor relations, and so forth. I'm going to welcome Mr. Imende to introduce his panelists and take this discussion forward. Welcome, Mr. Imende.
Thank you very much. Good afternoon, ladies and gentlemen. Now, I would like to introduce the next panel. I can see James is laughing because he knows. We have done a lot of introductions of his name and his qualifications alongside Robert. Prof, please come forward. So the first person I'd like to introduce I think the same applies to Prof. Professor Gideon Muigai, Senior Counsel. I'll just give a very brief snapshot of his CV. He is a senior partner at Mohammed Muigai LLP. He has an LLM from University of Nairobi and an LLM from Columbia University of Law, a PhD from University of Nairobi. AG Emeritus, Republic of Kenya. He is a member of the Permanent Court of Arbitration and a designate intensive panel of arbitrators. Welcome, Professor. James Holden is a partner at White & Case LLP, London office. He is in the dispute resolution group. He focuses on arbitration, especially in East Africa, and mainly in infrastructure, power, and oil and gas. Robert Will, also from White & Case, is a partner in dispute resolution, London office. Main area of focus, international arbitration, commercial litigation, with an emphasis on Africa. And last, and certainly not least, Mr. Collins Namachanja my teacher. He holds a law degree from the University of Nairobi, an LLM from the University of London. He's a fellow of the Institute of Arbitrators. He also trains Certified Regional Pathway Leader by the CIAB UK, an advocate of the High Court of Kenya, admitted in 1995, and a senior partner at Namachanja and Mbogwa Advocates. Welcome to the panel. Now, to start us off in this conversation on ethical considerations in commercial arbitration, I would like to just lay a basis of what our objectives is in this discussion. I would like us to explore what the role of ethical conduct in conducting arbitrations and how it builds the public trust in the process. I know from your London experience, it may not be a big issue, but I know from a local experience, it is a big issue. So to start with, Prof, the uptake of arbitration in Kenya was quite high a few years ago, at least in my perception. Do you think that the reason why we're not flying yet in terms of number of cases going to arbitration is because of ethical concerns about the conduct of arbitrators in the process or counsel in the arbitration? Why are ethical considerations important?
Now, the finality of arbitration and the lack of a supervisory role for any other body except the arbitrator and the panel itself, I think creates very, very serious challenges and requires that the highest possible ethical standards should be maintained. Now, in this country, I have no reason to believe that we have an ethics problem. I do know that there are random cases where conduct is borderline, and what in the profession gets round that conduct was beyond the pale. But I do not think that we have a systematic ethical challenge in our arbitration.
Thank you, Prof. Robert, an arbitrator should hold the scales of justice evenly between the parties, or at least should be perceived to hold the scales of justice evenly between the parties before him or her. His ability to discharge that duty is implicated, one, if he has a personal interest in the matter, or two, if he has some connection to a party or the case presented before him or her. Now, the matter is one of degree. It is not every interest, nor every connection that disqualifies. It has been said that everything is connected to everything else. And it can also be said that everyone, in some sense, is connected to somebody else. Now, to recuse or not to recuse, what are your thoughts on where the balance ought to be struck?
I think it's always a very difficult question if you have a potential challenge to make, and it's a discussion, an open discussion you need to have with your client, because the easy answer to this is to make an application to recuse an arbitrator and fail is one of the worst things you can do. and you do not want to spend the next 2 years facing the wrath of potentially a sole arbitrator who you try to recuse. And your client has to appreciate that. On the other hand, you do not want a client who turns around when the award goes against them saying, well, I told you this person had a conviction or had a so it really is a very difficult decision to make as a matter of strategy. As a matter of ethics, I think you have to investigate these things properly. Your hands are tied slightly because it is sometimes very difficult to find out about these degrees of connection. And you have to try to work out whether these are connections which are normal in the international arbitration community, which may not be quite so normal for the rest of the world, but the international arbitration community does accept that people sit on panels together, does possibly have multiple appointments, which mean they may be dealing with an issue in another case, or maybe speaking at conferences, or maybe members of the same faculty. So there are significant issues I think you have to investigate before you start making these challenges. And when I've contemplated them, and I have not made challenges, I've looked at them, but I have not made challenges because of the downside risk, I have tended to use the IBA rules to try to calibrate what I am actually faced by. You know, for those who know the IBA rules on conflict of interest, have a sort of green list, an orange list, and then there's a red list, part which is waivable and part which isn't. And you try and assess where you sit on that. That can provide some guidance, but it is very, very difficult. And I've had colleagues who've been quite bullish on this and hasn't gone so well. I've had colleagues who have been reticent on this and regretted it. So I don't think I've grappled with the complete rigor of the question, but it is a very difficult question, and you really need to get to the root of what it is you're objecting to and how serious it is. I think one of the positive steps that we're seeing in England now with the possible reform of the Arbitration Act, it is that there's going to be a greater, and you see it with the institutions already, a greater insistence on disclosure. And if the new Act has brought in a continuing duty of disclosure, which may help and may make things better, but it is a very difficult question.
Thank you, Robert. Collins, I'm coming to you just to expand on that. So consider this scenario, Collins. A party makes an application to you to recuse yourself on account of conflict of interest or bias. You consider their application and dismiss it. Naturally, your emotions were stirred when you were making allegations against your person and allegations against you, maybe corruption or something of the sort. Now, how should you as an arbitrator conduct the rest of the proceedings to assure the losing party in that application that you remain impartial? And as you answer it, just a rider to that question, what advice would you give to a party representative making such an application before you on the manner that they should make that application? Because, as Robert was saying, if you lose the application, you still remain before the same arbitrator. Mr. Machanda?
Thank you.
Thank you, Judge. Probably two hats to be worn there, one as a party representative and one as a arbitrator. Party representative, of course, weighing and balancing the opportunity cost of making a challenge that will not succeed, and probably the challenge also being thrown out by the High Court. The fallback probably will be to talk to the client and suggest these are the potential hazards lying ahead of us. But if the client then insists and takes a position as a party representative, of course, you are obligated to do that. I have a situation for domestic, Robert, where I pointed out to the arbitrator IBA guidelines. This is a red list, non-waivable, in fact, and I think your conduct falls right there. He said, no, I don't agree with you. So at that point, do I go to the High Court or do I proceed? But since I've already bitten the bullet, I said, let's go. I'm waiting to see how it turns out. Now, as an arbitrator, faced with a challenge, of course, when you look back, you'll ask, how has the respondent, because that's normally the party that comes up with this sort of applications, how have they conducted themselves from the beginning? And therefore, is it a legitimate complaint? Is it a legitimate issue they're raising against my person? Is it aimed at delaying or derailing? What is the circumstance? And so if I return a verdict of, sorry, I dismiss your application, I would have advised myself, I normally use that term, I advise myself that these issues brought before me are aimed at vexing my spirit, vexing my person, and potentially derailing the whole process. So at a personal level, when I made that decision, I have actually informed myself that I will be able to confidently carry on with arbitration. Citing a local example, I was faced with a sole arbitrator, faced with a series of accusations and all manner of, even live actually, during the live sessions. And somehow I maintained my cool, and the other counsel at some point wondered how I was not riled. So then it builds down to the personality of the tribunal. What's the personality of the tribunal? I know one senior arbitrator who got upset and told him, take your files and go away, leave me. So in terms of progressing with the dispute after a challenge of that nature or even altercations, you will then have to weigh, I would then have to weigh, is it more costly for the claimant if I insist and recuse myself for the cause of justice in favor of the claimant to pursue his, or should I then stay? What will happen next is likely that they'll come up with another application, they'll come up with something else, and they'll always be doing that. So broadly then, in the mindset of desiring the claimant to progress, considerations will have to be had then of recusing.
Thank you. James, do you want to weigh in this?
Sure, I think, making a challenge, I have brought some in my time, is a very difficult thing to do. And certainly I think there is then a sense that you almost can bias the tribunal by claiming that they were biased. And so that's certainly an issue. Going back to kind of the slightly earlier point as well about arbitration and the arbitral tribunal accepting a certain level of connection, I do think that perhaps there has been too much ease with some of these connections, and that actually, given how difficult it is to truly understand the depth of some of these connections, more needs to be done to try and have tribunals where, there are less of those connections, and for the arbitral community to kind of step up and say, look, okay, maybe this has gone too far. The only way to do that is to increase diversity on tribunals so that there are more people with, therefore, less connections who are actually sitting as arbitrators. Until we do that, it's going to be, I think, a very difficult thing to tackle properly, because there are always going to be those connections in place and you have kind of no option but to accept them.
Thank you for that. Prof, most arbitrators are men and women of letters. Most arbitrators are men and women of letters, including yourself. Now, because it is largely from their expertise and experience that they are appointed as arbitrators. Now, it is therefore normal that they have written books, articles, or appeared as experts in arbitration or in court. They may have a particular leaning on an issue or a subject. Does that render them biased as regards that issue in which they have written specifically about or testified as experts on? And what are your thoughts about an arbitrator presiding over a dispute in which an issue over which they have written or testified about is in issue before them?
That's quite complicated. To start with, there are not as many arbitrators in certain specialized areas as we would want to believe. So there is quite an incestuous community in some very high net worth disputes. And you will find the same people. I was involved in at the ICJ in the maritime dispute that involved Kenya, and was shocked to learn that the ICJ bar dealing with maritime disputes are less than 20 gentlemen. More, and I say gentlemen deliberately because that's the way it looked to me. And they are on opposite sides of the same cases, sometimes on the same side of the same case, and it's very hard to get out of that bar to instruct somebody new. And there is a sense in which certain aspects of arbitration are like that. And I think we have to call upon the ethical, the integrity of the individual arbitrator. The fact that I sat with you last week in an arbitration, and the following week you are acting as counsel in a certain, does not compromise either you or me necessarily, but it does create the necessity, therefore, for both of us to rise to quite a high ethical standard. Now, as regards the second part of your question, or if you have, for example, now my experience with exceed arbitrations, for example, is that the lawyers who argue state investor-state disputes know who stands on which side, on which issue. And I think that's how all of us work. When you're recommending an arbitrator to a client, let us speak X, you have studied to a very large extent their margin of error. For example, I personally believe that once we have accepted say, if you are an exceed committee looking at an award, and once the award is, once the reference is admitted by the committee, there is an automatic stay of enforcement. I personally, I am in favor of extending the stay until the case has been heard. Now, lawyers who have read my involvement will know that, and there is no way of hiding it. And so by the time the name is brought up, the lawyers will say his track record is in favor of this. Now, there are arbitrators who are in support of state investors. Almost invariably, in say 10 cases they have decided, 9 have been in favor of the investor and so on. So I do not think that it is possible to run away from your publicly acknowledged interpretation of things. But I think it is possible to remain an ethical person without, without in any way having what one would call a preconceived notion of how the case should be determined on the merits, not procedural issues, on the merits.
Just a follow-up to that, Prof. Should you, as an arbitrator, approaching such a case, disclose that you have written an article on a particular subject, which is one of the issues for determination in that arbitration?
That's a very difficult question. Do I owe a duty of disclosure? I don't know what the correct answer is, because the truth is that as an academic, for example, I have held certain views about, say, the Constitution, and have written about those views, and that is a matter of public record. As an advocate, I have argued positions inconsistent with my views, because those are the instructions of my client. I don't know whether I would have had to disclose to the court that in a certain article I wrote 10 years ago, I held a contrary view. I don't think I have such a duty. So I am not sure that the arbitrator needs to say, my mind is made up, because my mind cannot be made up unless the issue of law is matched to a set of facts, and those set of facts have never existed before. So I have no such duty in my opinion, but I do acknowledge it's a very difficult question.
Mr. Will, just a follow-up to what Prof has said. Is there a question of unconscious bias arising from that article you wrote, that expert opinion you gave, when you're presiding in a matter in that kind of context?
Well, if it's unconscious, it's very difficult to know whether but I think, I've always understood the test to be for those things whether do you have a closed mind or not. And I think writing a one-off opinion piece or something like that isn't an example of a closed mind. It's having a viewpoint, and the arbitral community values that there are people who contribute to the debate on these things. And it also has to be put in the context that almost all the law firms who will do, and investor state is the classic area for this, who do those cases do enormous due diligence on arbitrators. And if you're looking at a panel of either claimant side or respondent side, you'll have gone through their writings, you'll have done searches on that. You can form a view on whether someone has that bias, and you shouldn't, or unconscious, but perceived unconscious bias, and you shouldn't really be appointing someone like that. Now, you may end up with someone as the president, and you may have had less to do with that. But even then, I think it is unlikely that you would get very far in trying to say there is either bias or unconscious bias by expressing an opinion. It's much easier in the commercial world because the points of law are so endless and multifaceted that people that are very rarely written on something. It's only if you get into areas of insurance where they've commented on certain insurance contracts which have common clauses, that sort of thing. But on the whole, I mean, when we do the due diligence exercise on a commercial arbitration candidate, we're looking for an approach on things like document production, attitude to particular types of evidence, willingness to have experts. If it's a construction case, are they known to like certain theories or not like certain theories? But it's really at a very nebulous level, and you couldn't say anyone had a closed mind. I mean, I've won disclosure applications in front of people who've written articles saying they shouldn't have document production in arbitration. You know, they haven't got a closed mind, they have a preference. But if you can persuade them, I think that's what matters. So I wouldn't have that problem, but if I had the problem, I would hope I would weed it out of my due diligence unless it's come through a sort of presidential order.
Thank you for that. To what extent should you, as an arbitrator, be influenced by your peculiar knowledge in a particular area in arriving at a decision, especially if material on that particular subject or your peculiar knowledge of that subject has not been put to you during the proceedings?
I think I'll write on what has been said before, that one, by being appointed, then you know my philosophical inclinations about particular subject areas. And so when it comes to that, I've been appointed on account of my expertise in that field and that area, and therefore it's presumed again that the parties appointing me, which I'm sole arbitrator, then it's by concurrence, they know my position. But ordinarily, probably what would happen is at some time in the process, before the decision, I probably retire to render my decision. Find a way of bringing to the attention of parties, probably formulate questions or refer to that particular piece of writing or whatever it is and say, these have been the issues. While you're doing final submissions, whichever mode we have adopted, please look at this and comment and let me have your views on that. Probably that will be the safest way of making sure I bring to the attention of the parties so they can also let me know their views. Yeah, that's how I approach it.
Thank you for that. Mr. James, Professor Catherine Rogers has argued that international arbitration dwells in an ethical no man's land. And the reason is there is no code of ethics for counsel in international arbitration. Now, this forces both counsel and the tribunal to rely on either national codes or no codes at all. The ethical mess that I've just described has been likened to a teenager's bedroom. Now, two questions. One, is there a case to be made for a code of ethics for counsel in international arbitration? And two, as an arbitrator presently, if counsel conducts themselves in an unethical manner, repugnant to your conceptions of ethics, how do you deal with that situation, given that this conundrum we have about no common code of ethical conduct?
Yeah, I think that's definitely something that even if it's not a problem in a lot of actual arbitrations practically, certainly there can be a perception that it creates real problems.
And I think probably some council do try and take advantage of the fact that maybe they don't feel bound by their national standards. I think, as Prof was saying, there is, I think, a certain level of just personal integrity that is required in these things. I have codes of conduct that apply to me as an English solicitor. Now, the position on whether that applies to me in an arbitration is maybe a bit vague, but I think the safest approach is to assume that they do. And at a practical level, if I didn't want to have those codes of ethics apply to me, then I should have chosen a different profession. So I think we have to some extent, accept that people probably are willing to be bound to at least their national codes of ethics. Forming a global view of these things, as we were discussing this morning, I think can be difficult unless you kind of create a kind of lowest common denominator approach, but then maybe you're watering down the whole thing too much. So it's a difficult question. I think it's one that probably does deserve some, international body, the IBA, something like that, to look at and see if there is something that can be agreed that is meaningful. At least have those discussions, form a committee, see if something can be agreed. Taking the second part and, sitting as an arbitrator and seeing somebody act what I consider to be unethically, I think the first port of call is, well, what is their national standard? And do I think that they have reached that? Because what might be unethical for me is certainly not for other people. I mean, one thing that has always struck me as quite a strange arrangement, but it's very common, particularly in China, is where you have a mediation, you have a mediator come in and give you his views on the case, and then if you don't settle, he becomes an arbitrator. Now, that seems completely illogical to me from my Western perspective, but obviously that's totally fine to some people. So for me to get high and mighty about that, there's just no basis for it. If that's fine for other people, then I have to accept that. And to be honest, maybe it gets you to settle more quickly. So maybe there are some benefits to it if you know your arbitrator, the eventual arbitrator doesn't like your arguments.
Thank you for that, Prof. Now, judges and magistrates are answerable to the public. They are required to conduct proceedings in public. Their decisions are subject to public scrutiny. There is also the Judicial Service Commission, in whatever forms in different countries, which has a mandate to regulate their conduct. Now, these two forms of regulation are largely absent in arbitration. The situation is worse because the strictures for setting aside an award, it is very difficult to do so. Now, to whom are arbitrators answerable? There is this lack of a formal regulatory body, especially in domestic arbitrations or ad hoc arbitrations. Does this lack of a formal regulatory body to which they report play a role in dissuading private parties from adopting arbitration as a form of ADR?
On the face of it, there would appear to be an issue there. But in real terms, there isn't. Because, first of all, arbitrators are appointed by parties mostly who are represented. They are represented by counsel, and as my colleague said earlier, counsel do a very thorough due diligence, very thorough. And I think that is one safety valve, that no counsel will refer his client to an arbitrator who is suspect in any way. That's number one. Number two, arbitrators themselves appoint other arbitrators as chairman, for example. And once we have consulted with my colleague, the first thing that happens when a name pops up is that we both say, not him. Not her, not him. Again, that's safety valve number two. Number three is, if you want a career in arbitration, your reputation is everything, even more so than a barrister or a solicitor for that matter. Because once word spreads in that ecosystem that you are an unreliable person, for whatever reason, including for the manner with which, the manner in which you conduct yourself, like Collins was saying, then you are out of the market. So I think it has a self-cleansing culture. Once we look at that positively, it's not as, there isn't as much danger as one would imagine. I have had the great privilege to appoint arbitrators in quite a number of places, working with other people, and they give me a short list. And they say, look, we can, you can choose from this list. And we go down through the list and we say, what kind of person is he? What kind of background is she? What matters have they done before? And invariably you will find that the arbitrators who last the most are more central, they have no radical views. You can't last long if you have radical views. They are conciliatory, they are, they are good for. In fact, I have been in an arbitration, in a number of arbitration, where the other party appoints the arbitrator we wanted to appoint. Meaning that is a person with a good reputation. So that's my answer.
Robert, do you want to weigh in on that? Just from the UK experience?
I would agree with the Prof. The market reputation is very important, and that controls a lot of behaviour. I mean, it may be in some areas that it condones one or two things that we might not like, but on the whole, market reputation, I think, polices this. As I said before, there is an awful lot of due diligence done on these candidates. It's fairly rare that you get an arbitrator that nobody knows. And then everyone's in the same boat normally. They've got someone a bit left field. So I think there are protections there, and I think it's also, even if you get an arbitrator who you don't like, you have to judge them on what they actually do. You can't judge them on how you think they may be. And that's obviously going to play into whether you try to bring a challenge later, is how do they conduct themselves. And I say, if they are tricky, they're normally sophisticated, and they normally do not behave in a way that is so obviously bad. So it's, I think it is, on the whole, behaviour is moderated. Even when we get, oh, I don't want that one, or I don't want this one, you're still within quite a reasonable band on the whole.
Thank you for that. Collins. Now, the relationship between arbitrators and lawyers or party representatives who appear before them is different, very different from the relationship between the bar and the bench. The personal distance between the bar and the bench historically has been large, if I may use that term. If you compare it to the personal relationships between arbitrators and party representatives, the way they socialize, they meet in social contexts, they are members of professional societies where they meet and socialize. This is not the same as between the bar and bench, largely. Do you find this proximity problematic or potentially so?
Absolutely not, actually. I would say cheekily that the protection of the bench from the bar is to guard against the uninformed members of the public who immediately presume that there's something between you and the judges and the magistrates. So to guard against that public misconceptions, I think it's deliberate on the part of the bench to be kept away from the rest of us, if I may use it loosely and describe it that way. But again, when you meet those who are your colleagues, you'll smile and say hi, but the conversations rarely last. But when you come to the relationship between arbitrators and party representatives who are lawyers, I think I'll fall back on the underlying undefined ethical principles that govern arbitration, which are well understood by the arbitrators and the party representatives who are lawyers, so that some of it is quoted in soft law, but some of it is not. But it is a running understanding that though we may sit and share a board meeting, but we are not going to discuss the case at any level, the merits or demerits or otherwise, we will not discuss. That is commonly understood by the party representative lawyers and the arbitrators. So much so that it's well understood that again, that for you to challenge an arbitrator simply because they sit on the same board meeting or they were in a social function with a party representative, and so they were seen chatting, that's not sufficient ground. It doesn't, it's not consideration that the courts will give heed to. It's commonly understood. So I suppose we could say those are the common underlying nuances of what arbitration is all about, understood by the arbitration community, and that is how it works. So I don't find anything strange about that.
Thank you, Clarence. James, what can institutions, legal practitioners, and parties themselves do to promote diversity amongst arbitrators and reduce the potential for bias in the selection process?
You know, this is a thorny issue that I think the community has been grappling with for a few years now. As we've kind of been saying, you know, you want to do due diligence on your candidate, and you want to have some idea of what they think. And if it's a big arbitration, then you want them to be experienced. But that then leads you towards a small pool of people. And it becomes quite difficult for counsel to say to a client, yes, you could go for this old white guy, who has lots of experience, we know everything about him, but actually, you should go for this person over here. But we have no idea what their views are, and they've not sat on any big arbitrations like this before. That's a very hard sell, as the solicitors. But we, I think, have to try and find ways to encourage our clients to find more diverse minds, more diverse people. And I think, you know, the only ways that we can do that are something that has recently been done in the UK, maybe in Western Europe more generally, is a number of leading arbitral women took upon themselves to self-publish a guide to themselves. So, I am this person, I do this type of arbitration, and you know, this is my experience. That helps you
as a solicitor to go to your client, look, this person would be great. Look at the experience they've got. Look at what they've done. This is exactly what we need. Even if you don't have that kind of record on arbitral panels. So I think more of that kind of thing, more of that stuff that is not just people doing it themselves, but actually that's supported by institutions. And maybe it's more than one institution. Maybe it's the NCIA working with a number of other leading institutions around Africa to produce a list of the top 250 African arbitrators. And with a detailed bio on each one, what their experience is, and that can be used by the community to persuade parties that this is what needs to be done. And then obviously the other thing that institutions can be doing, to the extent that they are appointing arbitrators, is to make sure that they are going out there and making their panels as diverse as possible. And, you know, to an extent that largely requires them to do the same process that I was just discussing, which is to go out there and find out about these people, work out what disputes they would be good arbitrators on, and to then include them on their panels. I think that is how we can drive greater diversity.
Thank you. Prof, any thoughts on this?
Yeah, I think I would agree with the last statement made. The place to attack this problem is through appointing institutions, because they have the latitude to do it. And they will then open up for, say, young women, or let's say women in general, people of color in general, and then the ones that has opened up, they will get into the mainstream much, much easier. Right now we have this paradoxical situation where we all say we want an experienced arbitrator. Now, if he is experienced, he's already very busy. Now, if he's not experienced, he's outside the door. So those inside are very busy, and those outside are very idle. We need a way of opening the door slightly, and the way to do it is to get appointing institutions to open the door. And once those who are outside have had 1, 2, 3 matters, they will then join the experienced lot, and that way the pipeline builds.
Collins?
Just remembered an incident related to this, but it also builds into the pool outside Prof, their qualifications and competence and positions, and what they stand for. The example I use, I got a call from one of the colleagues, one of the South African countries. I was saying, I want to recommend you for this arbitration. I have been appointed as co-arbitrator in the UK, so both of us are looking for someone, so I need to recommend you, and you were right. I said, very well. So after a while, I asked, hey, Judge, how is it going? He laughs and says, no, now. My colleague told me, look, you hold this position within the judicial system of your country. I am Dr. So-and-so, but he is Mr. So-and-so. How are we going to balance the tribunal? I laughed and I told him, by the way, I saw that coming because things have been through before. So I told him, by the way, that's what it's going to look like. So in terms of creating this diversity that we're looking for, we too, who are on the outside, must be capable, must have what would be considered the basic minimum that would allow us to get into the door. Should it be slightly open for us? I think that would be my input.
Thank you, Collins. So, Prof, it's up to you to open the door wider for some of us. I'd like to invite the audience into this conversation. Can we take maybe 3 or 4 questions, first round? Anyone with a question? Yes, please.
I'll take advantage if nobody raises their hands. A couple of points. The first one is that the IBA has a guideline for party representatives, and that's a starting point where they talk about your relationship with the arbitrator and various things. You can easily Google it and you'd pick up on that. It's difficult for me to hear about diversity and not say anything, just simply because of the work that we do. Kenya, a few weeks back, somebody had published a list of 200 top Kenyan arbitrators. As you can imagine, that was music to my ears. I was very excited. And I looked at the list. Some names I knew, most names I didn't know. But that's not the point. The point is there was no methodology. I'm an academic. But the question is, how did you compile this list? And that goes to what the panel has said. So if I want to be able to recommend somebody that I know has actually written an award, you can be a co-arbitrator in 20 arbitrations and you've only done co-arbitrator. I will not recommend you. I want to recommend somebody who has either done sole arbitrator or presiding arbitrator that I know can actually write an award. I think those are maybe part of the information that we need in the public domain. I've been having conversations with various African colleagues in various African countries, including Kenya, on how do we produce those sort of credible lists. And there are GDPR questions, you have to get consent, blah, 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 and all of that. But how do we compile those lists so that you're recommending somebody that can actually get the work done? But the simple truth turns out that that door needs to be opened. It needs to be opened. And the last thing I would say is that the other thing for all of us to consider, which is something I keep harping on, is who are the people on your shortlist? If you can make it onto the shortlist, we told our trainees this morning, a little jump forward, a little jump forward. So if I can make it onto White and Case, I like putting them on the spot. White and Case, their shortlist, I know I've made it. So I'm closer to, at some point, getting an appointment. Because what the shortlist says is that we know this person, and this person is appointable. But if we don't know the people who are being shortlisted, we remain stuck with the 20, with the few odd people. The last thing is that domestic arbitration, we need to open up. Because the same problems we have in international arbitration, we have in the domestic field. Everybody wants to appoint Prof. Prof is one person. He's not getting younger. We want him to live longer and live a happy life and be strong. But we can't all appoint Prof. And that is the simple truth, that we do the same in the domestic field that we are complaining about internationally. And so if we open up domestically, more people will gain experience and be better prepared to step up to the international, for international work. Sorry I took longer than I should.
Thank you very much for those thoughts. Judges? This is,
Thank you. I think Prof has touched somewhat on what I wanted to ask Prof and the panelists, which is arbitrators wearing different hats, and as party representative and as arbitrators, and where it gets to a point where you are prominent enough and you have so many matters. Is it advisable that then you, in light of ethical issues that can be raised around you wearing these different hats, that you perhaps concentrate on acting as an arbitrator?
I have taken counsel, and I am advised that there is an effort to make me retire, led by a very distinguished professor, seconded by my own partner. I think that what tends to happen over time is that as you gain experience within the profession, the arbitration profession, I think you begin to take the fork in the road. And I think the road towards being a full-time arbitrator comes almost naturally, because the build-up of cases is such that you cannot now be litigating and doing your work at the same time. You will be delaying the awards. In fact, I have repeated this ad nauseum and made very many enemies, but I repeat, we have 2 enemies of arbitration in Kenya. 3. Number 1, our fellow lawyers. Because in their mind, arbitration does not allow them to charge the same way they do in a major commercial dispute. And most of them do not advise as they should. And within our other friends, our corporate lawyers, commercial lawyers, they write arbitration agreements without ever having had an arbitration. And they create this lunatic clauses where you have a dispute, say, of 100 million, and they say it will be heard before 3 arbitrators in Hong Kong. I mean, making it virtually something that is not attractive at all to the client. That's number 1. Number 2 is costs. We charge too much, in my view, because we want to recoup what time you would have had if you had gone to court. And that's a different model. I think we need to come marginally down. And number 3, delay. People come to arbitration so that they can expedite. They come and find us and find that we have 10 other files, and we are moving at a snail's pace. A case that started in 2020 will end up in 2025. It's not attractive at all to anybody. That would be my comment. So, Jerry's, I think there is a future for you.
Thank you, bro. Check us, George. Collins, just to weigh in on this issue of domestic arbitration appointments, is there a cartel? Is the door open enough to enable the judges of this world to write awards to make it to the whited case shortlist?
I think so. But a balance must be drawn because you grow. It's not something that you start today and tomorrow you are there. But yes, there's the aspect of mentorship, so that if I am mentoring your judges, then I have confidence in him that he's capable. And most likely, the first appointment he might get might be through me, because a claim will come and I think this is too small, or I'm too busy, and therefore who has gone through my hands, then I'll send it over to him. So at this domestic level, of course, then there's a concept of mentoring that I think at the local institution level has been a discussion that's been ongoing. And then the young ones also ought to be proactive, because if Prof is very busy locked up in his chambers, he's not likely to be seen outside. So someone ought to walk to him and knock his door and say, hey, I am here. In fact, I need to walk with you. Will you walk with me? So yes, there's possibilities, there are plenty of possibilities. Then the flip side is we actually need this pool behind us, because the pool before us, Prof downplayed this issue. But Prof, if we were to ask, let's create a list of commercial arbitrators in this country, you will get to a certain number and you won't go beyond that. So that ought to grow. When we come into ethical considerations as well, as Prof shared earlier on, we draw a list, and this is actually practical. I had a conversation with one of my colleagues. He asked me, you are a member of this institution, you know your members, give me a list of X number of people I want to appoint as commercial arbitrators. So I said, oh, so and so no, so and so X, so and so no, so and so he's conflicted. So we ran and remained with 3. And out of those 3, one was a relative of the lawyer, so he was out. One was very good, but at that point he was ill in hospital, so we remained with 1. So to cure that, we need those behind us to come.
Thank you very much. The last round of questions. I can see a hand up there. And another hand here. Another lady? Any lady with a question? Yes, those 3 questions. Thank you.
Thank you for the presentation. My name is Kevin Juguna, based in Nairobi. My question relates largely to the issue of independence and impartiality. And at what point should you raise this particular issue? If an arbitrator lacks independence or is impartial, this conduct will reveal itself in a very subtle manner. It's not always so obvious. So at times you might conclude after a combination of practices that indeed this arbitrator is not impartial. Then when you raise that issue at that particular stage, you are told you are sat through the entire arbitration process, you essentially acquiesced to that particular conduct. So how do you balance these 2 things when the conduct is not so obvious, yet the arbitration process was advanced to a stage where it is said that you cannot raise that particular objection at that stage? Thank you.
Thank you for that.
Okay, I do. Good day, everyone. My name is Ifeoluwa Akinte, a lead practitioner from Nigeria. And I do have more of a comment, just rather than a question, basically. So regarding the issue of maybe there being a space for those who are at the fore of arbitration at the expense of those that come in behind, basically. So I believe that there is the ELA training of the arbitration committee of ELA, that's International Law Association, Nigeria, where I was about a couple of months back, and the same issue came up, and it's like, okay, same faces you keep seeing. So Dorothy Ufort, who's a leading arbitrator from Nigeria, basically, was the one who gave this opinion and said, practically, maybe not everyone, maybe no one will create space for you out there. The duty is actually on yourself. However, this is not to take away the place of mentorship and recommending mentors recommending mentees. It's about first being diligent in the ones to work, basically, being an expert at something, like at least you are a force at something that you do, basically. Then that goes to talking about industry specific. There is, after then you can now exhibit your training and knowledge regarding arbitration, basically. And from there we got to know and we got to discuss and get to the point where arbitration practice basically is not just one that international arbitration especially is not something that you just say, okay, I know these things, I'm saying what I can understand. It's something that will push you out of your comfort zone. Go out, attend conferences, arbitration conferences, attend events and all of that. Be a voice that they can easily, so easily when, for instance, it's easier to relate with Professor Emilia there because one, you feel like, okay, she's Nigerian, she's familiar with Nigerian context. Basically, she also created a platform, like being here, for you to actually, she has been on, join this platform. So whenever you're thinking of Nigeria, you're easily able to think about her, to connect her to Nigeria. I'm also a legal practitioner from Nigeria, basically. So it's not out of place when there's a dispute from Nigeria, and you feel like, okay, yes, I met a young man from Nigeria. I mean, let me speak with law firm and see where we can live. So I feel that when you're talking about international arbitration, everybody's trying to swim, basically. Everybody has financial expectations. So even the arbitrators you see up there, they have financial expectations for the year, basically. So I don't really think not everybody is willing to actually share the money. Everybody's trying to look for how they can make the most. Mr. Robert here is trying to, at the end of the day, the profit must be high. So a lot of those things. So it's about taking charge, like being the author of your own story, basically. But first, which cannot be compromised, is knowledge about the industry, basically. So if you're talking about oil and gas, first, you must have that knowledge in oil and gas. If it's about taxation, have that knowledge first in taxation. Then you can now show yourself as having had the arbitration training and experience. I think that's how to take charge about the one's career. Thank you.
Thank you for that. The last question.
Jeffrey, allow me to convert myself into a panelist, because your panel today is a manel. So, this question of diversity, and I do want to add my voice to what Professor Onyema has said, and perhaps respond to a question that was raised possibly by James around these shortlists, if you will, or directories, if you will. There is the African Arbitration Association that profiles its members on a regular basis. Similar to what the Arbitral Women did, there is a directory of African arbitrators across the continent in different countries, different areas of practice. So it is a quick reference point for anybody in the global north, so to speak, to have a quick reference of where the arbitrators are. They actually have a map indicating who is where and where the areas of practice are. So it is a helpful resource. So for those of us who are sitting on this side of the room this afternoon, if you're not already a member of the African Arbitration Association, ask yourself why and see if you qualify and apply for membership. Besides that, this whole question of the door, and I'm being very cautious because some of the people who are sitting on this panel have opened doors for me in the past at a personal level. I do want to say that it doesn't take people who look, speak, and act like you to open doors for you. So in that regard, as you network, and I want to be very specific to the young people in the room today, please be very cautious in the way you network, the way you then seek mentorship. And I want to suggest that mentorship is not a formal process. Mentorship can also be by observation. You don't have to necessarily speak to Prof after this and say, Prof, I want you to be my mentor, and can we please come up with a mentorship program? No, you can actually learn by observation. You can learn by inquiry of how that particular mentor has risen up in their profession as you see it. You can also ask yourself about the context in which that particular mentor grew up in the profession. It was certainly different in our time. I think when I joined the Institute, and I'm speaking now as a member of the Chartered Institute of Arbitrators, there was indeed a dearth of lawyers. I think it was mainly members of the built environment that were the key professionals. So it was easy also then to build networks with different professions. So please look outside your own gene pool in terms of the people that you want to consider, your mentees, perhaps even your peers, because you cannot have a conversation with lawyers only on legal issues. You need to understand, for example, what the business community is saying about lawyering. In order to address those needs, you need to understand what the construction industry is saying about construction in order to understand what their peculiar needs are. And this is where perhaps you then build niche practices. So when, for example, we hear there is an absence of female practitioners in the marine space or maritime space, for example, what is the context of that absence? Why is that? So a lot of comments have been made also around ethics. Your own moral compass is going to guide you in a lot of ways. I have been having debates with several young people since Monday around what that moral compass looks like. No, it does not look like an institution telling you solely what it requires of you. You also have to know what you stand for and what what is black and white to you, and what is that gray area to you, and what is that area you will not play in. Beyond what your institution is telling you they require you as a professional, you need to ask yourself what you are bringing to the table in terms of your own moral compass, and these idea guidelines that have been given are just a guideline. You will have to decide for yourself as an arbitrator. Nobody will sit with you and hold your hand through your first arbitration. You will have to decide what is it that is palatable to the parties and what is not going to be palatable based on your own sense of morality. So having converted myself into a panelist, I rest on that note. And thank you.
Thank you very much. Wiser words have not been spoken. Thank you very much. I think from the last set of questions, only one question to deal with. James, do you want to take it? When do you raise a question of partiality if it has grown progressively in the proceedings?
Yeah, I mean, as we were saying earlier, the whole, it's a really thorny issue, the whole thing around challenging an arbitrator, and particularly where you haven't got solid information, it becomes harder and harder. Now, I think, you obviously have some time to act because you just need to pin it to something, and then normally most rules will be, 30 days or whatever from the date upon which you knew about it. So obviously that becomes harder the more and more that it's not one act, but a series of acts. But you just have to be clever in crafting your legal arguments around that. But obviously that all weighs into the strategic decision, which is, I think, as we all kind of agreed, is already kind of weighted against doing that because it's a very high burden, and if it goes wrong, you've made one of either your one arbitrator or one of your three arbitrators very grumpy, which is not a good thing to do. So, yeah, I just think when you're in that position, you're almost certainly not going to want to do it. I think what you need to do if you have those concerns is to go digging and see if you can find the reason for that apparent impartiality. And then if you can find that, if you were correct, if your thoughts were correct and there was something that hadn't been disclosed, then you have something more that you can deal with. But just going off those suspicions is very, very difficult, very, very dangerous. So I think you want to use that as a trigger to investigate, not a trigger to challenge.
Thank you, James. We've come to the end of this panel conversation. Please join me in thanking this panel.
Thank you once again, panelists. This has been a fruitful engagement, giving us a lot to, a lot of takeaways which we will be considering. I just want to take this time to thank all the panelists who have given us, or rather extended the discussions with us throughout the day. This started early in the morning with the panel that took us through the economics of international arbitration, where they discussed how we can make Nairobi and Africa in general attractive for international arbitration, which was then followed by the judiciary event, where we talked about the role of state courts in enforcement of arbitral awards. And then a nice way of now concluding the day, where we have discussed third-party funding, and we've also discussed the ethical considerations in commercial arbitrations, and particularly for arbitrators. I thank all the speakers that we have had today, together with thanking all the sponsors that we have had today, the team from the judiciary, and of course yourselves as distinguished participants for your engagement and attentiveness throughout the day. Perhaps let's give all of us a round of applause. Tomorrow marks the last day of the Nairobi Arbitration Week, where we will have a keynote address from the Attorney General of Kenya, which will be followed by an Oxford debate-style event that has the topic Crippling Arbitral Awards. That should be very interesting, and I hope that all of us will be able to attend it. And the last session of the evening would be on AI and arbitration, which will be followed by our gala dinner that will start at 6 p.m. There is tea and cocktails that will be served as from 6 p.m. and the venue for that is down the hall from where we are here, just on this same floor. And that cocktail event is sponsored by White & Case and Mohammed Regai, and we want to extend our gratitude to you for that. So as we conclude, I perhaps ask Dr. Mutuma and Mr. Kaseke to join us on stage for a photo with all the speakers of the afternoon, after which we will present to you our gifts, and then we can head towards the cocktail area for further networking. Thank you. Dr. Mutuma,
Jackie was discussing the
Thank you very much.